Hey guys, welcome back to my show. This is attorney Wilbur Salgado. Excuse the Disney shirt. As you may or may not know, I was supposed to have a nice vacation in Hawaii, but that was canceled due to the COVID-19 virus pandemic we have going on. So to keep things festive, and since I don't have court regularly anymore, I like to keep things comfortable. I hope I don't offend anyone by wearing this shirt. I'm just trying to provide some information for you and be comfortable at the same time. I've covered before the topic of filing a petition for dissolution of marriage if you want to terminate your marriage or if you want to terminate your registered domestic partnership. But in this video, I'm going to talk about what to do when you are served with a petition for dissolution of marriage or termination of registered domestic partnership. Stay tuned. So you were served with a petition for dissolution of marriage, and now you're heartbroken and you don't know what to do. Well, there's three things you can do. First of all, you can do absolutely nothing. You have 30 days in which to respond, typically, depending on how you were served, to the petition of dissolution of marriage. The petition should be accompanied by a packet of documents such as the UCCJEA declaration, the summons, and possibly a request for order requesting child custody and visitation orders, child support, or even alimony. Going back to what you need to do or what you can do, the first thing is do absolutely nothing. If you do absolutely nothing, that's called a true default. What will happen after the expiration period or the time in which you're supposed to file a response, like I said, which is 30 days in most cases, is that the petitioner or your soon-to-be ex-partner or spouse will file what's called a request for entry of default. At that point, once that document is filed, you cannot file a response. And typically the petitioner moves forward without you and makes requests from the judge on how to divide property, on how custody and visitation will be shared with the children, any support orders that may have been requested. Now, that doesn't mean that the other partner is going to come in here and blow you out of the water with unfair things. The judge still has some oversight to make sure that the things that are being requested are not overly burdensome or that there's no unconscionability to the extent that the judge made orders that were grossly unfair to you. But be careful because sometimes these orders are prejudicial to you. So a true default is never recommended by an attorney, or mostly never recommended by attorneys. The second would be what's called the stipulated judgment or stipulated default. In this case, you and the other partner come to an agreement to where you don't have to file a response, but you do sign a document under notary that you agree to certain aspects of the petition. The petition sets forth specific details of your case, of your marriage, of what you're requesting from the judge. And in that case, I'm going to discuss that a little later, but I just want to tell you that if you don't file a response, if you proceed by stipulated judgment or stipulated default, you would come to an agreement on all the issues that are raised in the petition so that you guys have an agreement on all or most all issues, and the judge signs off on it on a judgment. You become divorced and you can go along your merry way, never having stepped foot in a court under most circumstances. Now, the third option, and the option most cases go, in my opinion, is what's called contested. A contested divorce or a contested dissolution of marriage is exactly what it sounds like. It means you're contesting whatever the petition is set forth, and I'll discuss that in a little bit. So the response in that case, you check the box whether you agree with whatever the petition sets forth. And if those things mirror, great. Most of the time they don't mirror. For example, if the petitioner is requesting that alimony be awarded to him or her, but terminated with respect to you, the respondent who was just served with the documents, obviously you're not going to agree with that. Or at least I hope not. And you'll have to check the box that you don't agree with that. Does that make sense? So Now that you understand that, so that's the contested dissolution of marriage or contested dissolution of registered domestic partnership is commenced by the filing of a response, and that's the FL 120. It's about 2 pages long. It's not too terribly complicated to fill out. And then if you have children, you're going to want to include or attach the UCCJEA declaration, which is the FL 105. You'll want to include that as an attachment, and you're going to want to serve both of these documents to the petitioner by mail. You can't serve it. It's got to be someone else over the age of 18 who's competent and is not a party to the action. That means that they're not named in the lawsuit somewhere. And you can do that by mail. You would fill out the form FL 335, which is proof of service by mailing. And that's not a very difficult form to fill out, just as long as you're truthful and you actually mail out the response. You're going to take your response together with the declaration and the proof of service and file it with the clerk's office. I know right now, with the courts being closed, I think there's a drop box at some courts here in Stanislaus County. We do have a drop box where you can drop off your documents and they get filed at whatever fashion that they are being filed at. So please be aware of that some courts may be closed or the clerk's office may be closed. I said that I was going to talk about the contents of a petition, which basically mirror the contents of the response. And so the first thing that the petition usually addresses the type of request that it's making. A petition, like I said, could be for a dissolution of the marriage. It could be for a legal separation of the marriage, or it could be for the termination of a registered domestic partnership. Second thing would be the residency requirements. In order to file a petition for dissolution of marriage, in California, you have to have certain residency requirements. You have to have lived in California for at least 6 months and been a resident of the county in which you're filing your petition for at least 3 months. And you have to declare that in the petition, and you also declare that in the response. The third thing are the statistical facts of the relationship. When did you get married? When did you get divorced? Usually the petition and the response mirror each other. Both parties know when they got married. I would hope so. Like I always say, if you forgot the date you got married, it's probably the reason why you guys are getting divorced in the first place. But the separation date is usually the one that sometimes does not match up, because as you will find out, hopefully not, but more than likely, through an attorney, a date of separation is very important because it determines when it is that certain property becomes separate and stops being community property. That's a very, very important fact, a very important detail that you should know about and you should discuss with an attorney about. If you have minor children, obviously, you're going to discuss that in the petition. There's a section that discusses that, and there's also sections that discuss how you want visitation and custody to be shared, whether you're asking for child support and whether you're asking for alimony. The other remaining sections discuss separate property and the other area, which is community and quasi-community property. I'm not going to discuss that here because it can be very complex, and it's not within the purview of this video for me to advise you on whether certain property qualifies as separate or whether certain property qualifies as community property or quasi-community property. It's very dangerous ground to get into, especially in a video, and I am not providing specific advice to your case. This is, again, general advice to help you out. Lastly, when the response, there'll be a special request section. That's where you check the box. You're asking the court to make extraordinary requests. For example, if you're asking for attorney's fees or sanctions of some sort, you would go ahead and put that in. Most pro pers meaning people who are representing themselves, it's Latin for in propria persona. That means that those you normally would not know what to do in that section other than maybe check the any and other orders that the court may deem necessary. An attorney would know specifically what to write there if it's necessary or specific to a case. Again, if you recall, I discussed that there could be 2 avenues you can take once you're served with a petition for dissolution of marriage or termination of relationship. or registered domestic partnership. And again, it's the true default where you do absolutely nothing, which I highly recommend against. And the other one, which is the stipulated judgment. The stipulated judgment or stipulated default, you can have that accomplished through the help of an attorney who prepares a settlement agreement or the stipulated judgment. And again, that judgment would discuss all the topics I just discussed in that are addressed in the petition. For the most part, there may be some small minor details here and there that are not raised in the petition, but they primarily are. And so you can get the help of an attorney. My office can help you here in California. I service the counties of Stanislaus, Merced, and San Joaquin, which is Stockton, Merced, and Modesto. I can always help you out with that. And obviously with the contested divorces, I do those all day long, every day, except for now that we have COVID-19, things have not necessarily slowed down a bit, but obviously there's no court, so there's not much litigation. And as many of you know, I'm a litigation attorney. I'm always in court. I'm always in court. This is obviously a short video, but the last thing I do want to press forward is that, like I said at the beginning, once you're served with the petition of dissolution of marriage, there's other forms that accompany it. Primarily or typically, there's a request for order. Be cognizant of that. Look at what's checked in the box. Don't just ignore the packet and say, oh, my old lady's divorcing me, and throw it in the back of the room. You got to read it. You got to read it. I know it's going to be painful. There's going to be some stuff in there that's going to probably upset you, but you have to go through the motions and read it and talk to an attorney about it, or confide in someone who hopefully has some legal knowledge to help you through this. For those of you who can't afford an attorney, which I strongly advise against because I'm an attorney and I have to tell you that. But having said that, remember that the request for order may have hearing dates on it, or even other scenarios include a restraining order along with the petition. So you've got a dissolution of marriage going on along with a restraining order against you. So make sure that you look at those documents, because you typically would want to file a response. In some cases, you might not want to file a response. For example, when you have criminal cases or a criminal charge pending against you related to the divorce. So be careful about that. Talk to an attorney about that. Always make sure you review your documents. All right, guys, I pray that you're having a wonderful and beautiful day this April during the quarantine times. I like to come out here amongst the trees and come together with nature as one. I know I sound like a hippie right now, but it's helping me get through these isolated times, and I'm able to provide these videos and assist you now and in the future. When things get back to normal, or even now, if you have an emergency request that you need from the court, for example, emergency child custody and visitation orders, or you're facing domestic violence or threats from someone, a family member, a neighbor, please come see me. 209-300-7825. The courts are open on limited cases. You guys have a wonderful day.